नमस्कार दोस्तों। जैसा कि पिछला सेशन हमने अंतरा झा के साथ किया, जिसके अंदर एविडेंस की या उसी को आगे लेते हुए जब हम आपस में बातें करते हैं, डिजिटल एविडेंस तो नए एक्ट्स की आने के बाद उसकी एक स्पेशल सिग्निफिकेंस हुई, बट उसको कैसे स्टेप बाय स्टेप समझा जाता है, ये आज उसी का एक प्रयास रहेगा। डिजिटल एविडेंस इन कोर्ट, साइबर फॉरेंसिक, स्टेप्स बाय स्टेप्स, उसका क्या होता है बिटवीन द क्राइम एंड द चार्जशीट। दिस इज द जर्नी व्हाट Antara Jha, the cyber law expert, will take. Those who have missed the previous session by her can always log into the YouTube channel of Beyond Law CLC and can watch that along with other YouTube endeavors which we have taken in this journey. And we are thankful that everybody is appreciating the effort. Those who have missed it, they can always subscribe to the channel. Over to you, Antara Jha ma'am, and we are so glad that you have accepted our invite. Over to you.
Good evening, sir, and thank you for giving me this opportunity again that I'll be able to speak on this challenging topic, though it is important for everyone, whether the person is working as a student or as a law enforcement. So I feel that this topic is very important, though it is also a very challenging field. So, uh, so we'll start something with an example. Imagine it's 2 a.m. and your bank account in Bangalore has just been drained of just 11 lakh rupees and your account empty. There we can think that no broken lock is there, no shattered window, no visible thief, no fingerprints on a cupboard, and no eyewitness standing at the corner of a street. You are awake, panicking, calling the helpline, whatever helpline is available. Somewhere in another city, maybe Mumbai, maybe Hyderabad, maybe across the border in a country where you cannot even name right now. A laptop screen glows in the dark. And the person behind it, who is that person? They are already deleting logs and already pulling the SIM card, already moving that money through cryptocurrency wallets and two shell accounts before sunrise. So somewhere a device, a server, a network, a transaction log, or even a single click is silently carrying the story of what really happened. Now, here there is one question, that how do we catch that person? How to reach that person? Not just find them, but build a case so airtight that when they walk into a courtroom, the judge has no choice but to hold them accountable. That is exactly what cyber forensic is about. And today I'm going to discuss all these points, that step by step, layer by layer, from the moment the crime happened all the way to that charge sheet landing on the desk of a magistrate. So cyber forensic is not only a collection of technical jargon, but it is also a legal journey, an evidentiary journey, and ultimately a journey toward justice. So when we talk about the physical world, a murder investigation may begin with a crime scene, but when we talk about the cyberspace, the crime scene could be a smartphone in Patna, a server in Singapore, a cryptocurrency wallet. We can think that is in Dubai. A cloud platform can be in Ireland, and an attacker sitting in another continent altogether. So This is what makes cyber forensics one of the most challenging and intellectually exciting fields in the legal ecosystem. Though we can say, as I said, that it is also very challenging. The first thing we need to understand about cyber forensics is that it is fundamentally a race against time, not ours. Sometimes minutes also. When a cybercrime occurs, digital evidence begins to die immediately. RAM, that is the random access memory of a computer, where the part that it is that part which holds what the machine is actively doing at any particular moment, is collectively volatile. The moment you switch off a device, everything in RAM vanishes. This is not like a fingerprint on a glass that stays there until you lift it. This is evidence that literally evaporates. This is why, under Section 63 of Bharatiya Saksh Adhiniyam, which is the foundational provision for electronic evidence admissibility in Indian courts, entire argument around the reliability of digital evidence begins not in the courtroom, but at the crime scene itself. In that first the Supreme Court of India, in the landmark judgment of Arjun Pandit Rao Khotkar versus Kailash Kushan Rao Gorantayar in 2020, firmly clarified that Section 63 of BSA is mandatory for the admissibility of secondary electronic evidence. So now the question arises that what is the meaning of plain language over here? It means that if you collect evidence from a device, but you do not have a certified, procedurally valid certificate from the person who extracted it, testifying that the extraction was done properly, that evidence may simply not be admitted in the court. Years of investigation gone. The criminal walks free, not because he was innocent, but because the evidence was procedurally compromised. This is where cyber forensics and cyber law are inseparable twins. We cannot understand one without the other. Let us trace the full journey over here that a cybercrime is reported in India today. We can report it at, as we all are aware, that on www.cybercrime.gov.in, a portal launched under the Ministry of Home Affairs or at a designated cybercrime police station. Under the Information Technology Act 2000, as amended by the IT Amendment Act 2008, various offenses are cognizable, meaning police can register an FIR and begin investigation without waiting for a magistrate's order. Section 154 of the CRPC, now transitioning into the Bharatiya Nagrik Suraksha Samhita, which has replaced this CRPC, governs this FIR registration, and critically, cyber crimes must be registered at the jurisdictionally competent station, which is itself creates complications we will come back to. After this FIR, the first physical step is evidence collection. And this is where most investigations either succeed or fail before they have even properly begun. The moment a cyber crime complaint is received, the first challenge is not finding the criminal. The first challenge is preserving evidence before it disappears. When um, law enforcement receives a complaint, investigators begin identifying potential sources of evidence. These may include mobile phones, laptops, hard drives, email accounts, cloud storage systems, banking records, IP logs, telecom records, social media data, uh, cryptocurrency transactions, surveillance footage, CCTV, and network traffic records. A trained forensic investigator will arrive at the scene and follow what is called the order of volatility. This principle, established internationally by uh, the Internet Engineering Task Force in RFC 3227, which is a globally recognized guideline for digital evidence and archiving. It tells investigators which data disappears the fastest. First priority is RAM contents, then temporary files and system caches, then network connections currently active, then running processes, and only after all of that, the hard disk. This is the reverse of what most people think. People, we can say that they assume the hard disk is the most important thing. But by the time you get to the hard disk, the real story, what the machine was doing at the time of the crime, is already gone from volatile memory if you did not capture it in time. Digital evidence is unlike traditional evidence. It is unlike traditional evidence, and a blood stain may remain for years, but a log file may disappear within hours. A CCTV recording may overwrite itself automatically. A cloud server may rotate logs. A mobile application may, to some extent, we can say that it erase records after an update. Therefore, preservation becomes the first legal and technical battlefield. Now, here is where Indian law has historically they struggled. When we talk about the IT Act 2000 under Section 79A, it designates certain bodies as examiner of electronic evidence. It approves, this section approved agencies that are legally authorized to provide expert opinions. Their testimony is also required to make it admissible in the court. The Central Forensic Science Laboratory under the CBI is one such body. When you use a computer or a phone, you leave behind what are called digital artifacts. Just think of them as footprints, but in coding form. Every file you open has a timestamp, when it was created, when it was last accessed, when it was last modified. They are called MAC times. MAC means modified, access, changed, and they are incredibly revealing all these informations. A forensic investigator examining these timestamps can reconstruct a timeline of what happened on a device, in what sequence, and roughly when. But here is where it gets more complex and more legally interesting. These timestamps can be manipulated easily. An attacker who knows what they are doing can change the system clock on a device, alter timestamps, and create a false narrative. This is why forensic investigators use write blockers, hardware devices that allow them to read a hard disk without altering even a single bit of data on it. If you plug a hard disk directly into a computer without a write blocker, the operating system of what the computer may automatically modify the drive's file access timestamps the moment it reads the drive, contaminating the evidence. A defense lawyer in court can then argue that the evidence was modified after seizure and the entire chain of custody collapses. Now, what is chain of custody? Now, it is very critical concept in both Indian and international law. Every single person who touches the evidence from the moment it is collected to the moment it is produced in front of the court must be documented. Every transfer, every examination, every copy made of the evidence, all of it must be recorded. Under the Bharatiya Saksh Adhiniyam, chain of custody documentation is what gives electronic evidence its legal sanctity. If there is a break in this chain, if one constable handed a hard drive to another without signing it into a property register, the defense has grounds to challenge the authenticity of everything on that drive. The forensic investigator will then create what is called forensic image, an exact bit for bit of the original storage device. Not a copy of the files, but a copy of the entire disk, including deleted files, unallocated space, and hidden partitions. The image is then verified using a cryptographic hash, a mathematical fingerprint of the data, which is most commonly using the MD5, SHA1, or SHA256 algorithm. If even a single bit changes in the forensic image, the hash value changes completely, proving tampering. This hash value becomes part of the section 63 of Bharatiya Saksh Adhiniyam, and it is what allows a court to verify that the evidence presented was not altered between collection and presentation. Once forensic imaging is complete, investigators begin analysis. Now, whether the deleted files are covered, browser histories are reconstructed, email headers are examined, malware is analyzed, network logs are correlated. So these are such kind of analysis which is being done by the investigator. Financial transactions are traced, cloud records are requested, communication patterns are mapped, location data is examined, metadata that is data's data, is analyzed. So now what appears to be a random collection of digital records gradually becomes a timeline. So every device connected to the internet has an IP address, a numerical label that identifies it on the network, much like a postal address identifies your home. When a cyber criminal sends a phishing mail, launches a distributed denial of service attack, that is DDoS, or access your bank account without authorization under Section 43 of the IT Act, which deals with unauthorized access and has penalties up to 1 crore rupees in civil liability. They leave behind the IP address logs on the servers they interacted with. Further, identifying and legally securing these logs is one of the most critical and legally complex steps in cyber investigation. In India, Section 91 of CRPC uh, allows investigators to issue summons to any entity to produce documents or other things which are necessary for investigation, including digital records. ISP, that is, Internet Service Providers, are also obligated under Rule 3 of the IT Act, Intermediary Guidelines and Digital Media Ethics Code, Rules 2021, to maintain logs for a period of 180 days and to cooperate with law enforcement when served with appropriate legal orders. Uh, when we talk about Section 69 of the IT Act, it says that the government has the power to direct any agency or intermediary to intercept, monitor, or decrypt information in the interest of national security, sovereignty, or prevention of offenses. But here is the real challenge that IP address lie, or rather, they can be made to lie. Criminal uses virtual private networks, that is commonly known as VPNs, which mask the real IP address behind a server in another country. They use the Tor network, which routes traffic through multiple encrypted relay points across the globe, making it nearly impossible to trace the origin. They use public Wi-Fi at a cafe, meaning even if you trace the IP, you find the router that thousands of people use that day. This is where cyber forensic becomes less about the IP address and more about behavioral patterns. Metadata analysis and multi-layered digital artifact correlation is there. Now, the investigation of the 2013 Bazaar bomb blast in India, while primarily a traditional crime, but it demonstrated how even mobile phone tower data, called detailed records, that is CDR, and IMEI number tracking played a critical forensic role. The same principles apply to cyber crimes. IMEI numbers, device fingerprints, browser fingerprints, behavioral biometrics, all of these leave traces that a skilled investigator can connect even when the perpetrator believes they have covered their tracks. Now, after weeks or months of the investigation, evidence collection, forensic analysis, server log interpretation, and witness statements, the investigator must now translate everything into a charge sheet. Now, what an Indian criminal procedure is called a police report under section 173 of CRPC. This document must be filed within 60 days for offences triable by a sessions court or within 90 days for others, failing which the accused is entitled to bail as a matter of right. Further, for cyber crimes, the charge sheet is not a simple document. It must include the section 65B, that is section 63 BSA, certificate certifying every piece of electronic evidence. It must include the forensic examiner's report explaining in terms a magistrate or judge can understand what was found on the device and what it means. It must include the chain of custody records. It must clearly map each digital artifact to a specific legal provision under the IT Act or Bharatiya Nyaya Sanhita, and introduced updated provision for organized crime and telecommunications related offenses. The prosecution then carries the burden of proving beyond reasonable doubt the standard under Indian criminal law that the accused committed the act, that the evidence was collected lawfully, that it was not tampered with, and that it directly implicates the accused. Defense lawyers in cyber cases often attack the Section 63 certificate, challenge the chain of custody, argue that an IP address does not conclusively identify a person, and raise doubts about whether the accused was actually using the device at the relevant time. There are not frivolous arguments. They are legitimate legal challenges that a poorly conducted forensic investigation simply cannot survive. Now, the chain of custody is the documented history of evidence from the moment it is collected until it is presented before the court. Every transfer, every examination, and every storage location with every person handling the evidence must be recorded. In cyber crime trials, many cases do not fail because investigators could not find evidence. They fail because investigators could not prove the integrity of evidence. The judiciary consistently expects digital evidence to demonstrate authenticity, reliability, plus integrity. These are the 3 points on which judiciary consistently expecting to demonstrate. This is where many people imagine investigators opening laptops and immediately searching through files. In reality, that is not how professional cyber forensic works. This leads us to one of the most important concepts in cyber forensics, that is chain of custody. Now we can take an example, real world example. But one of India's most significant cyber investigators involved in the Cosmos Bank cyber attack in Pune. Attackers compromised systems and facilitated fraudulent ATM withdrawals across multiple countries. The investigation required coordination among banks, regulators, forensic experts, payment networks, and international stakeholders. The challenge was not merely identifying unauthorized transaction. The challenge was reconstructing a complex international attack chain spanning multiple jurisdictions. The Pune Citibank call center fraud in early 2000 was India's first major cybercrime case that tested our legal framework. Employees of a third-party BPO with access to American customers' bank account data defrauded those customers using social engineering. The investigation required call recording analysis, server log examination, and cross-border cooperation with American law enforcement. The accused were charged under Section 408, that is, criminal breach of trust by a clerk or servant, and Section 420, cheating of IPC, along with provisions of the IT Act. The case highlighted that our existing legal framework, even before the 2008 amendment, could be stretched to cover cyber crimes, but the gaps in dedicated cybercrime provisions were, we can say, were already visible. Another notable example was the Ames Delhi ransomware incident. Under this case, the attack disrupted critical healthcare services and highlighted the importance of digital forensics in national critical infrastructure. Investigators faced challenges involving malware analysis, attribution, recovery, and understanding the movement of attackers within networks. Now, this kind of incident demonstrate that cyber forensics today is not only about financial fraud, but also about public safety plus national security. The Jamtara cyber fraud ecosystem became another major lesson. Investigators discovered that many cyber criminals operated from relatively small geographic regions while targeting victims across India. The challenge was not the lack of evidence. The challenge was connecting thousands of digital interactions, SIM cards, devices, bank accounts, and transaction trails into legally sustainable cases. Another case was boys' locker room case. This case is of India in 2020. It was also one of the critical landmark case. Under this, a private Instagram group of young students in Delhi was sharing morphed images of girls and making sexually abusive comments. The Delhi Police Cyber Cell conducted a forensic investigation involving an Instagram account, tracing device seizure, and extraction of deleted images, deleted messages from group members' phones. This case was significant for how it tested for the application of Section 67A of the IT Act, which penalizes publishing or transmitting sexually explicit material electronically, along with IPC provisions on voyeurism and outraging modesty of the woman. Now, what was the complication? So, several of the accused were minors, which introduced the Juvenile Justice Act into the legal matrix. The case also raised questions about platform responsibility under Section 79 of the IT Act, which grants safe harbor protection to intermediaries, but condition it on the intermediary taking down reported content promptly upon notification. Internationally, the Silk Road investigation became a landmark example. Operating on the dark web, the platform facilitated illegal transactions using cryptocurrencies. Investigators from multiple agencies combined digital forensic, financial tracing, undercover operations, and we can say that blockchain analysis was also done to identify and prosecute key individuals. The Colonial Pipeline ransomware attack was also there in the United States, which demonstrated how cyber incidents can affect essential infrastructure. Digital forensic investigations helped trace cryptocurrency payments and identify operational patterns. The case highlighted the growing role of blockchain forensics in modern investigations. The Yahoo data breach was one of the largest breaches in history, which illustrated another challenge: attribution. Now, discovering that a breach occurred is often easier than proving who carried it out. So, attribution remains one of the most difficult problems in international cyber law. The 2020 Twitter account hack is a foreign case, but enormously that was instructive. In July 2020, the Twitter accounts of Elon Musk, Barack Obama, Apple, and dozens of others were simultaneously compromised in a Bitcoin scam that made over $120 lakh in hours. The forensic investigation by the FBI revealed that the attackers had used a technique called spear phishing, targeting Twitter's internal employee network, gaining administrative access to Twitter's backend tools. A 17-year-old from Florida named Graham Ivan Clark was identified through blockchain transaction analysis, tracing the cryptocurrency movement along with Discord chat logs and IP tracing through a VPN provider that cooperated with law enforcement. He was charged under Florida law with fraud and multiple counts of computer crime. Now, what makes this case remarkable from a forensic standpoint is that blockchain, which people often think of as anonymous, actually created an immutable, publicly traceable transaction that recorded that led directly to the suspect. Now, this brings us to the international dimension that cybercrime rarely respects borders. A victim may be in India. Again, the server may be in Germany. The email provider may be in Ireland. The cloud platform may be in the United States. The suspect may be in another jurisdiction entirely. Now, this creates significant legal challenges. Now, let us zoom out to the global picture because cybercrime does not respect borders. And neither can the law that fights it. The most important international instrument in this space is the Budapest Convention on Cybercrime, which formerly known as the Convention on Cybercrime of the Council of Europe. It is the first international treaty seeking to address crimes committed via the internet and other computer networks, and it remains the gold standard. Over 60 countries are signatories of this convention, and it creates a common framework for criminalizing cyber offenses, for procedural laws on evidence collection, and critically for mutual legal assistance between countries. India is not a signatory to the Budapest Convention. This is a significant policy gap that our legal scholars and practitioners have debated extensively, and it has direct consequences for, you can say, for cross-border investigation. Now, the question again arises here that why India is not has not joined. The stated concerns from the Indian government have historically been around national sovereignty, specifically the Budapest Convention's Article 32 provision, which allows law enforcement in one country to directly access data which is stored on servers in another country without necessarily going throughout that country's government under certain circumstances. India, along with several other nations, has resisted this as a potential infringement on sovereign control over data within its territory. Whether or not you agree with this position, the practical consequence is that when Indian law enforcement wants data from an American company, then they must go through the Mutual Legal Assistance Treaty, that is known as MLAT. MLATs are bilateral agreements between countries that allow them to request each other's assistance in criminal investigation. India has MLATs with the United States, the United Kingdom, and many other countries. But here is the brutal reality of this MLATs, that in cybercrime investigations, they are slow. Though I got chance to work into it, when we go with the procedure, it takes 1.5 to 2 years when we go with the procedure. So in cybercrime cases where digital evidence, particularly on cloud servers, may be deleted or overwritten in 30 to 90 days, an MLAT request that takes a year or more than a year to fulfill is often practically useless by the time. This is precisely why the United States passed the Cloud Act, that is, clarifying lawful overseas use of data act in 2018. That is Cloud Act, which allows American law enforcement to compel American cloud service providers to produce data stored abroad, and also creates a framework for bilateral executive agreements with allied countries that can bypass the slower MLAT process. India and the US have been in discussions around this Cloud Act, that is, as I said, that clarifying lawful overseas use of data act, which, if finalized, could dramatically speed up cross-border data sharing for criminal investigation. But as of now, this gap remains. The United Nations has also been attempting to create a broader global cybercrime treaty, with negotiations taking place in an ad hoc committee under the UN General Assembly. This has been contentious, with Western democracies pushing for a human rights centered framework, and countries like Russia and China advocating for a version that gives governments broader surveillance powers under the guise of cybercrime prevention. As of 2024, a draft text was finalized, but ratification and implementation remain uncertain. For standards, when we talk about standards, so international organizations like the International Organization for Standardization have given us ISO 27001 and ISO uh, IEC 27037, which provides guidelines specifically for identification, collection, acquisition, and preservation of digital evidence. Now, why do we reference this standard? Because it represents a globally peer-reviewed consensus on best practices. And when an Indian court examines whether evidence was collected properly, pointing to an internationally recognized standards, helps establish that the investigation followed a rigorous defensible methodology. Now, similarly, the NIST, that is National Institute of Standards and Technology Framework from the United States, particularly NIST SP 800 86 on digital forensics, is widely referred in Indian forensic circles because of its comprehensive technical guidance. Now, Interpol plays a critical role in international cybercrime coordination. The Interpol Cybercrime Directorate in Singapore runs operations like Operation Goldfish Alpha, which targeted router vulnerabilities across Southeast Asia, and Operation Falcon, which dismantled Nigerian cybercrime networks. Interpol issues red notices for internationally wanted cyber criminals. It coordinates joint operations between member country police forces and operates the Interpol Global Cybercrime Expert Group, which India participates in through the CBI. But Interpol is not a supranational police force. It cannot directly arrest anyone. It can only coordinate and facilitate. The actual enforcement action must be taken by the national police of the country where the suspect is located, and if that country is unwilling or unable to cooperate, Interpol hands are tied. This was illustrated starkly in the case of Hamza Bandela, an Algerian hacker known as BX1, who developed the spy banking Trojan that infected millions of computers and stole hundreds of millions of dollars. His arrest in Thailand in 2013 at the request of the United States required Thai law enforcement cooperation and extradition proceeding and American prosecution. The technical forensic work identifying him combined, we can say, IRC chat log analysis, Bitcoin wallet tracing, and server forensics across multiple countries. He was eventually sentenced to 15 years in an American federal prison in 2015. The case beautifully illustrates how technical forensics, bilateral cooperation, extradition law, and prosecution must all function together for justice to be delivered. Now, the reason these standards are preferred is not because they are fashionable. They are, we can say, they are preferred because they improve evidentiary credibility. Forensic conclusion becomes much more stronger when generated through recognized, validated, and auditable processes. Despite these advancements, challenges remain enormous. Encryption protects privacy but may complicate investigations. Cloud computing creates jurisdictional complexities. Artificial intelligence enables sophisticated cyber attacks. Deepfakes create evidentiary challenges. Cryptocurrencies complicate financial tracing. The Internet of Things, that is IoT, creates millions of new sources of evidence. Quantum computing may reshape future encryption landscapes. Even every technological advancement creates new opportunities and new legal questions. And India has approximately 1.4 billion people and an internet user base of over 750 million. Our cybercrime reporting has increased by over 300% in the last 5 years, according to the National Crime Records Bureau. Yet our cyber forensic infrastructure is woefully under-resourced. There are only a handful of dedicated cyber forensic laboratories at the state level, and many district police stations have investigating officers who have received no formal cyber forensic training. Now, the DPDP Act 2023, India's landmark personal data law, which is a significant step forward, but it also creates a new complexities for the forensic investigations. When investigators want to access data held by companies, so those companies are now navigating DPDP Act obligations around data minimizations and purpose limitation alongside law enforcement requests. The law enforcement exception exists, but its boundaries are still being tested. Jurisdictional overlaps between the state police, the CBI, specialized agencies like the Serious Fraud Investigation Office, and sector-specific regulators like SEBI for securities related cyber frauds and RBI for banking fraud create coordination problems that slow investigations. The National Cybercrime Reporting Portal has helped centralize reporting, but the investigation in itself often falls back on the local state police who may lack the technical capacity to handle these kinds of sophisticated cases. Judicial capacity is another honest challenge. Our judges are brilliant legal minds, but many were trained in an era when document meant paper and evidence meant physical objects. The concept of metadata, hash values, forensic imaging, blockchain analysis, these are not intuitive. Expert witnesses in cyber cases in India often spend most of their time in court not explaining what the evidence shows, but first explaining what a hard drive is. This is, we can say that a training and awareness gap that needs to be filled urgently at the level of our judicial academics. The Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita, and Bharatiya Sakshya Adhiniyam that came into effect from July 2023 represent India's most comprehensive criminal law reform in over a century. The BSA, in particular, has modernized the provisions around electronic evidence, but practitioners are still in the early stages of understanding how these will be interpreted by courts. Section 57 of the BSA, for instance, deals with electronic records and their admissibility, building upon the Section 63 framework while attempting to address its practical difficulties. Now the cyber forensics therefore exists at the intersection of technology, law, human rights, governance, and public trust. When people think about cybercrime investigations, they often imagine dramatic hacking scenes. The reality is far fascinating. Cyber forensic is the art of turning invisible traces into admissible evidence. It is the science of converting data into facts. It is the discipline of transforming facts into legal proof. And ultimately, it is the process through which courts convert proof into justice. Between the crime and the charge sheet lies a journey that most citizens never see, that every cyber crime is a human story. Behind every phishing email is a person who lost their savings. Behind every ransomware attack is a hospital where systems went down and patients were at risk. Behind every dark web data breach is a family whose privacy was violated. Cyber forensics at its best is, we can say that it is a bridge between that human story and justice. The law gives us the framework, the Constitution of India, through Articles 20 and 21, protects the accused right even in digital investigation. The right against self incrimination, the right to privacy affirmed so powerfully in the Puttaswamy judgment of the 2017. But those same constitutional values protect the victim's right to a fair investigation, to evidence that is collected properly, to a prosecution that will stand in front of the court. Cyber forensics is not just a technical discipline, it is a legal, we can say it is a legal responsibility. Every investigator who does not follow proper protocol is not just being sloppy, they are potentially handling freedom to someone who caused real harm to real people. And every lawyer, every judge, every policymaker who does not understand these processes well enough is a gap in the system that criminals will find and exploit. The question is not whether cybercrime will become more sophisticated. It will definitely. But the question is whether our law, our forensic infrastructure, our international cooperation mechanisms, and our judicial capacity will grow to meet those challenges. That is the challenge of our generation in the legal profession. And from where I sit, I am cautiously but genuinely optimistic because conversations like this one are exactly what are we can expect that change begins. Uh, but awareness and to understand this digital forensics, we need to take the step. We need to understand that what kind of technology is taking and how to make it admissible in the court. Thank you. Question?
Aji ma'am, today we will not take question answers, but as we if we were seen in the previous session, there was a request that you should speak in English. That you have done. If you could just summarize this entire session in around 10 minutes in Hindi, that would be fascinating.
So what I want to explain over here that we need to understand that technology is evolving every second. So it is very important to understand that we can definitely face lots of challenge that how to make it admissible in the court.
I'm saying
So
हिंदी में इसे 10 मिनट में समझा देंगे तो हिंदी वाले व्यूअर्स भी देख लेंगे उसको अलग से एक बना
क्यों सर? हाँ हाँ ठीक है। मैं ये कह रही हूँ कि टेक्नोलॉजी सर हर सेकंड बदल रही है और हर सेकंड बदल रही है तो हमारे जो लॉ इन्फोर्समेंट हैं, जो लीगल फ्रेटर्निटी से जुड़े लोग हैं, उनके लिए भी ये काफी ज्यादा चैलेंजिंग हो जाता है कि उसे कोर्ट में कैसे एडमिसिबल कराया जा सके। अब जैसे इंटरनेशनल लेवल की बात करें, इनफैक्ट इंडिया में भी अगर हम बात करते हैं तो जैसे बहुत सारे ऐसे क्राइम हो रहे हैं जिसके लिए डायरेक्टली अगर मैं देखूं तो लॉज नहीं है, लेकिन कम से कम मुझे ये लगता है कि जो है हमें वो पता होना चाहिए। इंटरनेशनल प्लेटफॉर्म पे अगर मैं बात करूं कि एमलेट जो अभी हम लोगों ने बात की, अब वो भी इतना लंबी प्रोसेस है। मुझे मौका मिला था इस पे थोड़ा सा काम करने का, तो अगर प्रोसीजर से जाते हैं तो लगभग 1.5-2 साल तो कम से कम लग ही जाते हैं। और इतने में क्या होता है कि कितने क्रिमिनल जो है वो क्राइम लोग करके लोगों को ट्रैप में फंसा गए होते हैं। तो एक तो ये है। अच्छा, जो सेक्शन 63 भारतीय साक्ष्य अधिनियम जो कहता है उसमें कुछ पॉइंट्स बहुत जरूरी है, जैसे आ, ये जो जब जब कोर्ट में उसे एडमिसिबल कराया जाए तो एक तो प्राइमरी और सेकेंडरी एविडेंस का वो तो हमें पता है, लेकिन अब जब एडमिसिबल कराना है तो जो सिस्टम है वो सही तरीके से काम कर रहा हो, फंक्शन कर रहा हो, डैमेज ना हो। तो ऐसे कुछ पॉइंट्स हैं जो हमें समझना चाहिए जब कोर्ट में उसे एडमिसिबल कराना है ना। और जो जो सेक्शन 63 है उसका इंटेंशन ही यही है कि ये देखना कोई एविडेंस जो कोर्ट में पेश किया जा रहा है उसके साथ टैंपरिंग नहीं हुई हो, है ना। इस वजह से उसको वहां पे अटैच किया गया है। तो इसीलिए हमें यही समझने की, जितने भी केसेस मैंने के इंडियन केसेस मैंने डिस्कस किए, फिर इंटरनेशनल प्लेटफॉर्म पे भी जो भी मैंने मुझे लगा कि केस डिस्कस करना चाहिए वो सारे केसेस मैंने डिस्कस किए। अब हैश वैल्यू भी कैसे निकालना है, तो देखिए कुछ तो सॉफ्टवेयर भी अवेलेबल हैं, और नहीं तो फिर हम जो जो एक्सपर्ट हैं, जो एफएसएल के एक्सपर्ट्स होंगे, हम उनसे भी मदद ले सकते हैं, क्योंकि हैश वैल्यू क्या है कि आप जितनी बार निकालेंगे वो चेंज होता रहता है। और जब आप जो जो सर्टिफिकेट बनती है उसमें आपने देखा होगा कि वो सारी चीजें मेंशन करनी होती हैं कि हैश वैल्यू क्या था, है ना। तो इस वजह से हमें बड़ी बारीकी से ये सारे काम को करना होता है। और जब एक्सट्रैक्शन वाला पार्ट होता है तो ये भी जरूरी है हमें समझना कि उसकी एक इमेज बना ले, है ना, ताकि जब जब रिक्रिएट करना पड़े तो ऐसा ना हो, क्योंकि ये ट्रेडिशनल क्राइम नहीं है कि ठीक है इसे हमने ऐसे निकाल लिया हो गया। जब एक्सट्रैक्शन वाला पार्ट होता है ना उसमें ये भी चैलेंजिंग होता है कि वो जो जो एविडेंस है वो डैमेज ना हो जाए। तो इस वजह से उसकी एक कॉपी हम बना लेते हैं। सही टूल का भी यूज होना बहुत जरूरी है। अगर सही टूल यूज नहीं होगा तो क्या है कि एविडेंस जो एक्सट्रैक्शन होना है सही तरीके से नहीं हो पाएगा, और फिर कोर्ट में उसे एडमिसिबल कराने में बहुत मुश्किल होगी। तो यही मेरे साइड से है।
थैंक यू मैम, आपने उम्दा तरीके से लोगों को समझाया। एंड जल्द ही कभी दोबारा सेशन करेंगे। शुक्रिया, थैंक यू।